Okay, good afternoon, colleagues.
Afternoon, Hilda.
Good afternoon, ma'am.
Good afternoon. Thank you guys for being here. Let me just looking for my study guide so we can start. Can you see the study guide on your side?
Yes, we can.
Okay, thank you.
Yes.
On paragraph 2.4.3, ranking.
Yes. Okay. So before we start and before I forget, I'm getting a lot of queries about assignment 2, the multiple choice, question 1 and 2. I think there's a numbering error there. Guys, read tutorial letter 102. That mistake has been addressed there. Thank you. Anything from your side that you'd like to bring to my attention before we proceed? Nothing. Takanai, switch off your camera, please. Okay, so last week we were busy with study unit 2, natural bonds, and we went, if not mistaken, until page 28, activity 2.1. I think we completed that activity. So now we proceed with the ranking. Any questions so far? Remember, guys, we all must participate. Okay, so for our notarial bond, the ranking, like in your mortgage bond, for an example, in the bond itself, the mortgage bond document itself, there will be a clause where you will find the ranking of that bond, whether it's first mortgage bond over the property or second or third and so forth. However, with notarial bonds, there is no ranking clause in the bond itself. However, the preference of that bond depends on the date of registration and not the date of its execution. And for insolvency purposes, the ranking will be determined by the Insolvency Act. Okay, so we proceed to the next paragraphs. I think they are self-explanatory, except if there's something specific that you would like me to go through. I think maybe paragraph 29, page 29, paragraph 2.5.2. Just take note that where parties are married in community of property, there is a joint estate. And in terms of section 15.2 of the Matrimonial Property Act, both spouses, they must consent if a joint estate property is going to be hypothecated, alienated, and so forth. So also here, if a property that belongs to a joint estate is going to be hypothecated, it's going to be mortgaged by a notarial bond, both spouses must consent to this act of hypothecation. Questions so far? Okay. And with regard to juristic persons, just take note, especially with regard to trust, you can never act on behalf of a trust that is not yet registered at the master's office. You must have the letter of authority to act on behalf of the trust, for you to act on behalf of the trust. So if you have an idea that one day you want to form a trust, or the trust is still in the process of being registered at the master's office, you've lodged your trust deed, but it's not registered yet. That trust has not yet come into existence. Therefore, you cannot act on behalf of that trust. Also, when the trust does come into being, you cannot ratify whatever acts that you have entered into on behalf of that trust. Unlike in your companies and close corporations where you can ratify those acts. Questions, colleagues? Okay.
Ma'am, just a clarity.
Yes.
So, if I have been appointed, but the trust is not yet registered, I cannot act.
Your appointment has to be confirmed by the master.
So
you cannot act first. You cannot act until you have the letter of authority to act on behalf of the trust.
If you have been appointed, is it possible that you can be appointed as a trustee and then the trust is not yet registered?
First, okay, we'll unpack this when we deal with the trust, but now that you've asked the question, let's clarify that. So let's say you are the founder of the trust. Someone must have an idea that I want to start a trust. That person, we call them the founder of the trust. Then the founder will appoint trustees, all right, to act on behalf of the trust or to look after the interest of the trust. So you are going to be appointed and you're going to accept the appointment, all right? Your acceptance together with the trust deed and other supporting documents will have to be lodged in the master's office for registration. If the master is happy with the documents that you've lodged, the trust will be registered. Only after registration has been effected by the master, the trustees will be able to act on behalf of the trust.
Thank you, ma'am.
Yes. I think there's a hand there. Ms. Ramamuel, you can go ahead.
Hi. I just want to, I think it gets confusing if you talk about appointing a trustee in a trust deed. That gets confusing. What happens, the trust creator and the trust deed will nominate somebody, but the actual appointment gets done by the master once he registers the trust. It's just easier if you use that kind of clear terminology, then everybody understands the difference, because the same thing, of course, happens in a will. You will nominate somebody that you want as executor, but until the master approves it and appoints them, they have no authority. They're merely nominated. And I just thought it might help to clarify.
Yes, thank you. Yes. There's a hand. Please go ahead.
I wanted to ask whether, since a trustee cannot act without the trust being incorporated or being finally initiated into law, so does the trustee by himself incur personal liability for the transaction in which he will have concluded on behalf of the trust itself?
Do we have any volunteers? Ms. Ramuel, you cannot answer that one. Anyone to try? Yes, go ahead.
I think for me, the question is a bit confusing and almost answers itself in that a trustee cannot act on behalf of a non-existent trust. So it first has to be registered before any activity can take place.
Anyone to add to that? Yes, Morey.
I think since the trust is non-existent, no person may purport to be acting for on behalf of a trust, because it's not there, it doesn't exist at law. So the person will be acting so implies there would have to be any consequences arising from their actions.
Okay. Anyone to add? Pokela, your hand was up.
Sorry, I got clarity on something else. Thank you.
Oh, okay. So yes, basically, until such time that the master of the High Court registers the trust and appoints the trustees, the trust is non-existent. There is no trust. So you cannot act on behalf of something that does not exist, especially when we're talking about trust, right? However, let's say you were dealing with companies. I don't mean to confuse you here. You're dealing with a company. You can act on behalf of a company yet to be registered. And those acts that you have entered into before the company came into being will have to be ratified once the company has been registered. So with your trust, you cannot ratify anything. Whatever act that you have entered into before the trust was registered, it was for your personal capacity, not for the trust, if I may put it like that, not for the trust. Pokela, are you happy, cleared?
Yes, thank you, ma'am.
Okay. Any other question? Murray, your hand is up.
Oh, sorry, I have to take it down. I have no question. Sorry, ma'am.
Okay, okay. All right. Do we have any other question? Do we proceed? Okay, so you as the notary, whenever someone approaches you and they are acting on behalf of someone, be it a juristic person or a natural person, you need to ask that person for proof of authority to act. Do you have the permission from a particular person to act on their behalf, which they must give proof on writing? All right. All right, so there are self-assessment questions from page 30. We can quickly go through those questions, only those that you think are a bit problematic. We cannot go through all the questions. Any questions that you specifically would like us to look at? Yes or no? Do we proceed to the next study unit? Yes, Pogela.
Before we continue, can I ask who is responsible for the registration of the notarial bond, not the execution of the notarial bond? To be specific, I'm asking who is responsible for taking the notarial bond contract to the deed registry? Is it a conveyancer or is it a notary?
Ms. Ramwell, would you like to come in there?
I can come in there. Wow, but it's actually quite a difficult question that he's asking. So if you go to the Deeds Registries Act, I can't remember which section now, but anyway, the Deeds Registries Act is very specific about who may lodge deeds at the deeds office, and it lists them, and it says a conveyancer practicing at the seat of the deeds registry, who is registered at the deeds registry, or somebody employed by that conveyancer, or in certain instances, government departments. So the short answer is that deeds are always lodged at the deeds office by conveyancers, not by notaries, although often notaries are also conveyancers. But your question wasn't that in the beginning. Your question in the beginning was, who is responsible for registering a notarial bond? And that is maybe something different. Normally the notarial bond will be executed and entered into at the behest of a financial institution, and they will appoint their attorneys, their notary, and their conveyancers to register it, although the person lending the money and executing the notarial bond will be the one who will have to pay the legal cost. I think that might cover it. If there are more questions.
Pogela?
The reason I'm asking this question is because most of the conveyancer's work includes taking or filing a deed of transfer, of which ultimately it's related to immovable property. So the same as a notarial bond, a notarial bond is related to a movable property than a mortgage bond, which is related to immovable property. Hence my question. Thank you.
I hear you, Pogela, but I'm not understanding your explanation there.
Sorry about that. All I'm asking is a notary. Is it a notary or is it isn't it that we're dealing with a notarial bond and
Yes,
its registration?
Correct.
So all I'm asking is that who will file at the deeds registry for the registration of the notarial bond? Is it a notary or is it a conveyancer? Because in most instances, by law, it is required that a person who files and at the deeds registry in relation to a deed of transfer or the alienation of land is a conveyancer. The notary has nothing to do with going before the deeds registry in relation to the filing of that movable property. So my question here is, I'm sorry if I lost you along the way, but then who submits this file to the deed registry for registration of a notarial bond?
Okay. Your question is actually not that difficult, but you're going round. Be it the conveyancer or the notary or the candidate attorney or anyone employed by the conveyancer, they can physically take the notarial bond to the deeds office and lodge. I think that's what you are asking.
Sorry, ma'am. Can I come in there if you don't mind?
Yeah.
So we're talking about notaries in this particular module, and I think my colleague's question is not specifically looking at the work of the conveyancer, looking at the work of the notary. Is it not the notary that registers the notarial bond in the deeds registry, or anyone working for the notary, which notary might not necessarily be a conveyancer?
Okay. So his question, if I got him correctly, he will correct us, who physically lodges in the deeds office long before registration comes into play. And as Ms. Ramuel has already explained, that the conveyancer can lodge, the candidate attorney can lodge, the prep clerk can lodge in the deeds office. However, registration is not just anybody.
Can I come in here, please?
Yes, please.
Okay, so it's Regulation 45, which says only conveyancers or people employed by conveyancers or in certain exceptional circumstances, state departments can lodge deeds at the deeds office. No notary, no attorney. The reason is that conveyances are recorded at the deeds office. They have special numbers. They have pigeonholes. They have access there. So while you're absolutely right, a notary will do the execution and drafting of the notarial bond. But unless he is also a conveyancer, he will have to get to a conveyancer who is registered at the deeds registry, at the local deeds registry, to hand it in, or the conveyancer's article clerk or somebody employed by the conveyancer. And of course, the registration of a notarial bond is very different from a deed of transfer. A deed of transfer has to be signed before the Registrar of Deeds to be executed before the Registrar of Deeds. Notarial bond is already executed. It simply gets registered. So it gets handed in at the deeds office. After 7 days, it comes on prep, and the conveyancer will just put it forward for registration. He doesn't have to sign anything or do anything else with it. But this is getting way more into detail than what we need for this particular course.
Sure.
Okay,
Yeah.
I think I've covered that. As I say, Regulation 45.
Thank you. I've got.
It's got to be a conveyancer does the lodgement.
Yeah. Okay. Thank you, ma'am. So, Pokela, yes, we are now diving more into the sea of conveyancing. Right. So for you to be able to lodge as the conveyancer in the deeds office, you need to have a lodgement number. So that let's leave it for conveyancing discussions. But to lodge, physically lodge in the deeds office, anyone can just put it in there. But your conveyancer, you only lodge under a specific conveyancer who has a lodgement number in the deeds office. Okay, Sandy, you've been waiting for us. Please go ahead.
No, it's fine, ma'am. If I'm taking back my apologies, maybe I was not in the previous class. On page 23 of the study guide, ma'am, can you please just make me understand, orientate me on the issue of what is it that they said? They say a notarial bonds that purports to hypothecate a South African ship in terms of the Merchant Ship Act and an aeroplane as intended in the Convention of the International Recognition of Rights of Aircraft. What is it that they're talking about there?
Okay, so a ship, it's a movable property.
Yes.
Aircraft, it's a movable property, right? So basically, you cannot register a notarial bond over those two properties.
Okay. Okay.
Yeah.
Thank you.
Okay. Any questions before we move on? Okay, so my last question to you guys was, do you want us to go through the self-assessment questions? Do you have any specific question there that you think it's a bit problematic? Yes, no, we move on. Okay, so yes, that concludes study unit 2, and we move on to study unit 3. And then we're now dealing with anti-neutral contracts. So can I add or emphasize, colleagues, that it's very important that you prepare before coming to class. I'm sure the questions, self-assessment in the previous study unit, you will definitely have something to ask, but because you didn't go through them, or you still need to go back and read, study that particular study unit, for now you will not be able to answer, ask any questions. But you're most welcome to email me, or in our next meeting, you can take us back. We unpack whatever issues that are problematic. After all, that's why we're having this meeting, to assist each other. Okay, so anti-neutral contract. According to your own understanding, what is an anti-neutral contract and what is a post-nuptial contract? What's the difference between the two? Yes, sir.
An antenuptial contract is one that is executed before solemnization of the marriage. It's quite funny because I always had the understanding before reading this module that an antenup is one that is executed after solemnization of the marriage. But apparently, an antenuptial agreement or a marriage agreement is the same as a prenuptial marriage agreement. Then a postnuptial one would be one that would be executed obviously with the authority of the High Court after solemnization of the marriage.
Yes. Anyone to add or dispute what has been said?
Ma'am, it's Sandy. I
Yes.
just want to add that on antenuptial contract, the parties agree to exclude the system of community of property in their marriage.
Yes.
That's all.
Okay. Anyone to add? Okay, thank you, colleagues. I get worried when only few of you participate. I would be glad if all of us would give an input. Okay, so as our colleague has already given the differentiation there, and the nuptial contract, you enter into it before the marriage is solemnized, not the registration thereof, but the signing of the actual agreement by the parties. Whereas your post-nuptial contract, it's after the marriage has been solemnized, and now you want your marriage to be out of community of property. Remember, our South African system, every marriage is automatically in community of property, except if you enter into antenuptial contract before the marriage, then your marriage will be out of community of property. But by default, it's in community of property. So the aim of our antenuptial contract is to regulate the matrimonial property dispensation between the spouses in such a way that community of property and profit and loss is excluded. Let's go to... Okay, so remember, antenuptial contract is concluded before the marriage has been solemnized. So it is based on the assumption that Peter and Mary are going to get married, all right? So it does happen that Peter and Mary decides not to go ahead with their marriage. So what happens to that antenuptial contract? Assuming now that it has been registered in the deeds office. What happens to that antenuptial contract? Anyone to try? Yes, Murray. Murray, go ahead. Jabulile, you can go ahead.
I think the contract will be void and unenforceable.
Murray?
Yeah, the contract will be of no force or effect since it has got no marriage to regulate.
Okay, anyone to add?
Yes, ma'am. So it is dependent on a suspensive condition that an actual marriage will take place and be solemnized. So if that does not take place, then the contract is null and void. So its effect is suspended until the marriage is solemnized.
Okay. Yes, Jabulile. Jabulile.
Oh, sorry, no, my hand is not up.
Okay. Murray, do you still want to add something? Okay, so that says
I think, and I think that's all I wanted to contribute, ma'am.
Okay, thank you. So yes, even our customary marriages, parties entering into customary marriages, if they want their marriage to be out of community of property, they will have to enter into antenuptial contract, right? our customary marriages by default is in community of property, right? And parties who are entering into civil unions, they can also enter into anti-nuptial contract. Questions or comments? Yes, no? Remember, colleagues, you need to go back and study this work. We just scratching the surface here. Yes, Pokela.
Ma'am, on issue of your marriage, if the parties did not have an antinatural contract,
Pokela, we missed part of your question. Can you please start again?
I'm saying on page 39, it says there all marriages entered into the republic are in community of property and profit of and loss, unless it is contrary expressly excluded in an antinatural contract. So my question is, based on this statement here, creates an illusion that the community of
You
property.
said on page 39, hey?
Yes, 3.5, first paragraph.
Okay.
This statement creates an illusion that the community of property and the community of profit and loss are one and the same thing, is it?
Let me just get to that page. Okay. So all marriages entered into in the Republic of South Africa are in community of property and of profit and loss, unless the contrary expressly stated in an anti-mutual contract. So your question is, why do you say it creates an illusion to, please repeat that last part?
It creates an impression that these two, community of property and community of profit and loss are one and the same thing. So my question is it one and the same thing?
Okay, so tell us, Pogela, when parties are married in community of property, what does it mean? With regard to their assets and debts.
I don't mean to like. Okay, I'll answer your question. When they are married in community of property, it means they share everything, their burdens, they share their assets, and the whole. There's a joint estate in ultimately, by the end of the day, their assets are joined together and they are formed to be one.
Same as in when in profit and loss. They're joined together even in profit and loss.
No, but then the thing is, maybe there was a new law passed down since I knew or studied about community of property, and
Okay,
maybe
profit is what you have, what you own, what is yours, your assets. The loss is your debt. You cannot say that it's an asset. It's a loss. It's a debt.
so is it one and the same thing?
It's the same thing.
Thank
You
you.
cannot say I marry you in community of property. However, your loss is your loss. I don't want part of it. I only want to enjoy the beauty of being in community of property. I want to enjoy only the assets. Yes, More.
Can I come in, man?
Yes.
Yeah. I want a very basic example. If, for instance, in community of property, say you own a house together, because it's in community of property. If that house is going to appreciate in value, say from 1 million rand to 10 million rand, the profit is the appreciation, and then you share in it. If it's going to depreciate from 1 million rand to 100,000 rand, you are going also equally to share in the loss. The profit and or loss is the variance between the original value and then what then transpires, whether or south was in terms of. That's my understanding. Thank you.
Thank you, Murray. Anyone to add?
I agree with Murai, ma'am.
Okay. Anyone to disagree? Are you happy, Pogela?
Yes, I'm happy, but then at the beginning of the study guide, they made it seem like there are two separate systems, matrimonial property systems. But then now, when you turn to page
It's in
39,
community of property and out of community of property.
no, I mean community of property and community of profit and loss. They made it seem at the beginning of the study unit 3, they made it seem like it's two different things. But then right now, they make them seem like it's the one and the same thing. But then, thanks to my colleagues here, they got to answer me. Thank you.
Okay. So maybe I can suggest that perhaps you, if you still have your family law study guide, maybe you need to go back there and refresh. Yeah. Okay, so let's proceed. Okay, so where was I now? So with regard to customary marriages, yes, I've already mentioned that being in customary marriages or someone intending to get married in terms of customary marriage, they can enter into antenuptial contract. All right. And then so the registration requirement, we already know that antenuptial contract, it has to be entered into before the solemnization of the marriage. Registration can happen,
Ma'am,
yes,
ma'am, sorry, I've just got one small question.
yes.
I think it's slightly a rights issue. On the second paragraph, which gives the husband authority to enter into further customary marriages, it specifically notes that the husband. What is the position with regards to the wife?
Okay, so we're not gonna get involved into that kind of discussion. I know there's a lot of noise about the new act or bill or whatever about women being able to marry many husbands. So let's leave that for the lawmakers. For now, the law is that the husband can marry many wives.
It's not yet in place.
Not yet.
Quite discriminatory. Thank you, ma'am.
Yeah. So there's a hand there. There's someone whose camera is on, and so I cannot see whose hand is up. Katleho, you can go ahead.
I just wanted to ask under paragraph 3.2.2. It says, however, spouses in a customary marriage where the husband does not have a customary.
So when you're reading from the guide, you please refer us to say first paragraph, second, so that we are able to follow where you are.
Sorry, it's on page 34,
Yes.
3.2.2,
Yes.
the second paragraph.
Okay.
It says, however, spouses in a customary marriage where the husband does not have a customary marriage with anyone else may enter into a civil marriage with each other. What does that mean?
So it means that it's Katleho.
Yes, it is, ma'am.
Yes. So let's say Katleho, you are married in terms of customary marriage to your husband, and he has no any other wife in terms of customary marriages act. So you can go and enter into civil marriage.
Okay.
Can I help, ma'am? I think
Yes.
it means if a man is only in a customary marriage with one woman, then they can go and have a civil marriage. But once he has two wives, they cannot enter into a civil marriage. Two or more wives, he cannot enter into a civil marriage.
Okay. Thank you.
Ma'am, can I just make a follow-up? What happens when if he marries, how can I put it? If the first wife gives consent to marry the second one, he cannot have two civil marriages.
No.
Okay.
According to the Civil Marriage Act, you can only have one wife and one husband.
Okay, ma'am, thanks.
Yeah. Any other question? Pokela?
Yes, ma'am. Just to add on that topic, whenever you are entered into a customary marriage and you then alternate to marry into a subsequent civil marriage, then it's by law very permissible. But then if you are in a civil marriage and then you want to enter into a customary marriage or marry someone else, then that marriage has to be dissolved, and then the estate has to be administered in that way of saying like the assets are then separated according to the matrimonial property system, and then from then that's when we can the parties can take it forward whether they continue with the new marriage in which it will be a customary marriage involving two or more spouses. Thank you.
Thank you, Pokela. Anyone to add or question before we proceed? Ms. Ramwell, would you like to say something?
Thanks for the opportunity. No, I don't have anything to add except that I think we're getting a little bit sidetracked here by going into different types of marriages and how they can be done, which is stuff that the students should have learned under matrimonial law. Whereas this is really just about the contract that the parties enter into to control their property rights after the marriage.
Yeah.
But anyway, it's fun. It's fun to chat about these things.
Okay, thank you. Okay, so we proceed, colleagues. Then yes, so now we are still looking at registration. So the execution antenuptial contract has to be notarially executed. So antenuptial contract is one of those documents that can exclusively be executed by a notary, not a conveyancer, not an attorney, nobody else but a notary public. And then I think it's mostly self-explanatory. Okay, so we are to parties page 35, paragraph 3.3.1.3. So if a minor is getting married and antenuptial contract is being entered into, the parents or guardian must assist that minor. Otherwise, that antenuptial contract will be null and void, with the result that the marriage will be in community of property and it cannot be ratified later. Okay. And then okay, so on page 36, there's activity there. I think it's quite straightforward. So we're not going to waste time on that. So appearance by represent. Okay, there's a question, Pokela.
Yes, ma'am. On is it 3.3.1.1? It's page 35.
Yes.
The second paragraph there, the last line on the second, it says, I think I need clarity on this one because it says the intended spouses need not to both sign on the same day.
Yeah.
Can I please get a clarity on that? Because it says that signed, the execution of an is complete when the notary signs the document, but then the spouses need to be present or they need not to both sign on the same day. But then if you check a requirement for an antenuptial contract, it says that both parties need to have the intention to conclude such a contract. So here, can I get a clarification on this?
Okay. Do you have anyone to try to assist Pokela? Yes, Murray.
Yeah. The parties need not both sign on the same day. If the parties have in principle agreed to the contract and its contents, and for instance, one party could be in Cape Town and the other one could be in Johannesburg, and maybe the notary is in Johannesburg, there shouldn't be nothing to stop the party who is in Johannesburg to sign before the notary and then go on to move elsewhere. And then, as and when the partner who is in Cape Town can make it to the notary's office, then goes and signs. I think that's the import of that clause in brackets.
Yes, that's correct. So remember, both parties need to sign. So before the signing, remember, we're gonna make an appointment with the notary public. We go there, tell the person our story, what we want, with accrual or without accrual, and give all the details. So the notary will draft the contract, and then and then there will be another follow-up meeting where we go and sign the contract. So life happens. I might not be available on that day to go and sign or appear before the notary to sign the contract. However, my partner is available, so nothing stops him from going to sign the agreement. I will go tomorrow or whenever I am available to sign the contract. So only after both our signatures have been appended on the document will the notary sign the anti-nuptial contract, and that will conclude the signing of or the execution of the anti-nuptial contract. Does that answer you, Pokela?
Yes, thank you, ma'am.
You're welcome. Yes, there is a
Ma'am,
question. Yes, go
I've
ahead.
also got a question. It's along the lines of Kokela's question. It's related to the statement before that, particularly as it relates to the witnesses who have to both be present at the same time. So that does it mean if one spouse signs today, both witnesses have to be there on that particular day? And then if the other spouse signs on another day, the same witnesses will have to be there on that other day, or it can be different witnesses who sign at the same time on that particular day.
Oh, okay. So, okay, anyone to try that before I make my comment? Yes, Marie. Marie, go ahead.
Yes, ma'am. Yeah, I'm not quite sure, but I think if when the signing of any contract is being done, and the provision is that a signatory should sign in the presence of two competent witnesses. I think it doesn't matter if one signatory has got a separate set of two competent witnesses from the other. So I think it is not necessarily that they should be the same pair of witnesses as and when each party signs.
Okay, anyone to add?
Yes, can I add?
Yes.
Based on the witnesses being able to attest to the intentions of the parties and to their signatories, it says here on, is it, sorry for that, on 3.3.1.6, it says that it is customary thereof, but then it is not imperative, and the registrar has authority to dispense with this requirement, which means the registrar can waiver this requirement of the witnesses being there to attest whether both parties signed on the same day or not. So I think I've answered the question.
Yes, you did. So, without necessarily taking you guys back to your law of contract, you need to remember what's the purpose of a witness. So we're not gonna get into that discussion now. So it does happen. I think one colleague mentioned that he gave an example of one party being in Joburg, the other one in Cape Town. I'm based here in Joburg. I will sign the anti-nuptial contract here in Joburg. The notary public here, there's nothing stopping him or her from sending the same anti-nuptial contract that I've signed to a notary public in Cape Town to oversee the signing of that contract by my partner, right? So obviously it will not be the same set of witness. That is not practically possible, right? And remember, last week, we mentioned, and also in study unit 1, that a notary is an officer of the court, and whatever has been commissioned by the notary, it's taken on the face value of it to be true and correct. It cannot be contested, right? So, yeah. So let me stop it there.
No, I understand, ma'am. I
Yes.
understand. I think it also actually helps me understand the statement, the first statement in the following paragraph of the contract being executed by different notaries.
Yes. Yeah. Okay. Any other question? So, yeah. Okay. Where was I? So yes, to the place, page 37, place and date of execution. Again, remember your antenuptial contract has to be executed before the marriage has been solemnized. So the importance of the date in your antenuptial contract is to exclude any disputes or possibilities of being unsure whether the antenuptial contract was executed on the date of the solemnization of the marriage, before the marriage was solemnized, or after, right? It does happen that the antenuptial contract is executed on the date of the wedding. There is nothing wrong with that, as long as it happens before the marriage has been solemnized, before you've been declared to be husband and wife, right? But if it happens on the same day, your notary needs to indicate in the antenuptial contract that this antenuptial contract was solemnized at 10 o'clock in the morning before the marriage took place at 10 in the afternoon. All right. Okay. Questions? Happy? All right. So after the antenuptial contract has been solemnized, the notary has 3 months to register the antenuptial contract in the deeds office, right? If it's been executed in the country. If it was executed outside the country, then there is 6 months period for it to be registered in the deeds office. Failure thereof, it means your notary or your attorney will have to approach the court and apply for extension or permission to register for late registration of the antenuptial contract. Yes, sir, you may go ahead.
Ma'am, sorry to take you back just a little bit. On appearance by representative, it appears not to be quite conclusive what the position is in South African law. Is it either position that a representative may appear or may not appear?
Oh, okay. So, yes. What happens is, Ms. Ramuel, would you like to come in there?
If you'd like me to come in, then yes, I
Yes,
will come
please.
in there. Okay, so it often happens, it very often happens that the couple will go and see an ordinary attorney to do an antenuptial contract for them. Maybe it's a friend, maybe it's somebody they know and trust, maybe it's somebody who's already done their will.
Can I please interrupt you there? So what she's explaining now, it's not only for antenuptial contract, even with your servitude, it can happen. Please go ahead, ma'am.
Okay, so they'll go and see the attorney who feels that he's perfectly competent to do it. So what the attorney will then do is draft an antenuptial contract, and he'll have both the prospective husband and the wife sign a power of attorney saying, we authorize this attorney to register, to execute and to register an antenuptial contract like the copy we've got here and that we've initialed before a notary. And then that attorney with the two powers of attorney will come and see a notary, maybe in another firm, and say, yeah, I'm acting on behalf of Annie, the wife, and I'm acting on behalf of Tabo, the husband, and I'm signing an antenuptial contract that looks exactly like the one they signed for the power of attorney before you. And that is perfectly legal. It can be done. Sometimes there's some discussion in law magazines about whether it's the right thing and whether it's not right, because then you as a notary don't know for sure that the attorney has in fact discussed this with the clients and explained to them that what their rights are, but it's perfectly legal and it gets registered in the deeds office like that. Any questions?
So, Mrs. Ramuel, so there is no definitive position on that. It can be either. A representative may appear or they may not appear.
As far as I'm concerned, they may appear. And legally, they may appear and it's registered like that, and it's accepted by the courts like that. I'm just saying that there's some discussion about whether it's ethically good, whether it's best practice, shall we say.
Okay. No, thank you. I understand.
Any other question? Thank you, ma'am, for that explanation. So I think, colleagues, we're going to leave it here for today. We will continue with this study unit in our next meeting. Do you have anything to say before we say our goodbyes? Okay, so it seems we are all happy.
No, just to say thank you for your time. We really appreciate these sessions.
It's a pleasure.
Thank you.
Thank you so much.
Thank you very much, ma'am.
Thank you so much. Thanks to both.
Yeah, please, colleagues, prepare yourself before you come to class so that you're not left behind in the discussions. So please, we're gonna proceed with study unit 3 next week, and possibly start with study unit 4. So go through study unit 3 and look at study unit 4 as well, and prepare your questions. And yes, and then we assist each other. So thank you for making time to be here. Really appreciate it. Thank you, Ms. Ramuel, for being here and your contribution. It's very appreciated.
It's a pleasure. It's nice to be here.
Thank you. Bye, colleagues.
Bye, ma'am.
Bye, ma'am.
Bye.
Bye-bye.